Hi guys, welcome back to the class. So we were doing operation and mismanagement, wherein we had covered the 4 sections and we were left with only one section, that is your basically class action suits. Okay? So before we proceed further, let's recall all the sections. 241 says application to tribunal for relief. 242 is basically powers of tribunal. 243 is consequences for termination of agreement. 244 is right to apply. 245 is class action suits. Okay? So we are now doing class action suits. Now, in your book, kindly mark this as important. Please mark this as important. Now, there's a word called as class action suits. Class action suits. Now guys, what does this line mean? So it is basically a suit or an action taken by a particular class. It could be equity shareholder is one class, preference shareholders is another class. Equity may be 10 rupees wala, 10 rupees wala is one class, 100 rupees wala is another class. So that means it is basically a suit filed by a member of a single class. It could be equity shareholders or a preference shareholders or a creditors or debenture holders. So that is just an understanding of what is a class action suit. Okay. Now why does this happen? So it says, in case if a company has done something wrong, ठीक है, जैसे सत्यम में हुआ था, there were shareholders whether Raju, the guy, the company का director has done wrong with the shareholders. There were few shareholders in Mumbai, few shareholders in Delhi, few shareholders in Kolkata, few shareholders in Chennai, few in Jharkhand, few in Visakhapatnam, and everywhere the people has filed a case against one company which is called as Satyam Limited. So at that time, the power in the Companies Act, the supreme power was High Court. And High Court, different areas, different states have a different High Court and their jurisdiction. So for example, West Bengal High Court says, sir, okay, Satyam, Raju, you are not guilty. Bombay High Court said, Raju, you are guilty. Assuming Rajasthan High Court, the Jaipur High Court says, Satyam, you are not guilty. So that is the reason it took so many years to make Satyam Limited guilty and Raju Lingam as the person who was guilty. It took so many years. So now when Companies Act got revamped, when it came 2013, everything got changed and says, boss, if an action has to be taken against a company, wherein the company is one, the problem is one, the cause of action, the reason of the action is also one, the same, then rather than filing multiple suits, boss, the category can file one single suit and all the multiple applications would be consolidated into one single application. That is called as class action suit. Now let us assume there are 10,000 people who are filing the suit, 10,000. So all the people will not hold their hand and come to the court, right? Keeping one in distance, or come, we all are applicants. No, they can choose one lead applicant. However, if there is no consensus between the applicants, someone says Ram would be the lead applicant, the other says Sham would be lead applicant. So there's a fight, there's no consensus for the lead applicant, and in that case, the tribunal will decide who will be the lead applicant. Okay? Now there is a small difference, distinguish, you have to understand. In section 241 we did in the previous class, the wrongdoing was on the members by the company. Same thing here also the wrongdoing is against the members by the company. So sir, what is the difference here? What is the difference? See, the difference between 241 and 245 is the aggrieved party here is basically the members when you're doing 241. In 245, two categories of people are covered. members and depositors. Members and depositors. And the wrongdoing in 241 has to be done by the company or the directors or the members. For example, majority shareholders are suppressing or giving an action which is oppressive to minority. So majority shareholders are overriding minority, or minority are overriding majority, either of it. Okay? But in 245, companies is already covered, directors also covered, members also covered. So this is the same category of 241, but here CA, CS, LLB, CMA, all these people are also covered. Auditor, if you have given something wrong in audit report, company secretary in practice, you have done something wrong in secretarial audit report. A cost accountant, you have given something wrong in cost audit report. A LLB, a expert, you have given a wrong statement. And there are people, there are members or depositors who have suffered because of you. They have a right to take action against you. This is a basic difference in 241 and 245. There only members are covered, here members and depositors are covered. There the wrong action has to be done by company, directors, members. Here company, director, members, CA, CMA, LLB, any person can take it. Understood? This is the basic difference in 241 and 245. So let's understand. Members or depositors can file an application to tribunal on behalf of the members or depositor for seeking any or all of the following acts. Number 1, to restrain the company from committing an act which is ultra virus. Restrain matlab rokna, to stop. To stop the company from committing an act which is ultra virus. To restrain the company from committing breach of any provision of the company's mahua. To declare a resolution altering mahua as void. To restrain the company and the director from acting on such resolution. To restrain the company from doing an act which is contrary to the provision of this act, against the law basically. To restrain the company from taking any action contrary to any resolution passed by the members. To claim damages or compensation or demand any suitable actions from or against, this is important, company or its directors for any fraudulent, unlawful or wrongful act. This was there already in 241. Very important. Auditor, including audit firm of the company who gave an improper, misleading statement of the particulars made in the audit report. Okay? Fair. Any expert, advisors, consultant or any other person for any incorrect or misleading statements. H, to seek any other remedy as a teammate deemed fit. So guys, institute can ask you what are the orders under 245. So tribunal can pass any of the following orders. Understood? Now application. This is amended. Application. Guys, this is amended, okay? This is important. Let's see. In case of members, the first category, I would say this is A. Depositors would be B. In case of members, company having share capital, company not having share capital. Company having share capital, company not having share capital. So company having share capital, company not having share capital, matlab guarantee company. So first is same, minimum 100 members. Minimum 100 members or 5% of total number of members, whichever is less. So this is the first category. 5% of total number of members, whichever is less. Second category. In case of a listed company, members holding 2% of issued share capital of a company, or in case of an unlisted company, members holding 5% of the issued share capital of a company. वहाँ पर अपन ने क्या सीखा था? 100 members or 1/10 of total number of members, whichever is less. यहाँ पर क्या बोल रहे हैं अपन? 100 members or 5% of total number of members, whichever is less. Guarantee में same 1/5 of total number of members. उधर सीखा था members holding 1/10 of issued share capital of company. यहाँ पर in case of listed 2%, in case of unlisted 5%. ठीक है? Depositors में almost same ऊपर जैसा, minimum 100 depositors or 5% of total number of depositors. Minimum 100 depositors or 5% of total number of depositors, whichever is less, or any depositor to whom the company owes 5% of the total deposits of company. Any depositor to whom the company owes 5% of the total deposits of the company. So guys, this is amendment. ध्यान रखना. Now, few important points. Public notice shall be served on the admission of application on all the members or depositors. All the similar application prevalent in any jurisdiction shall be consolidated into single application, and a class of member depositors shall be allowed to choose a lead applicant, and in the event the members or depositors of a class are unable to come to consensus, that is razamandi, they are not able to choose a leader, the tribunal will have the power, the T will have the power to appoint a lead applicant who shall be in charge of the proceedings from the applicant's side. Okay? The T will appoint the lead applicant. Two class actions for the same cause of action shall not be allowed. It will be consolidated into one single application. The cost or expenses connected with the application of class action shall be defrayed by the company, underline this, shall be defrayed by the company or any other person responsible for any oppressive act. That means it will be paid. Whatever lawyer ka fees, stamp duty ka paper, affidavit ka paper ka जो भी खर्चा लगेगा, it has to be paid by the company or the person जो guilty prove होता है. Any of the passed by the T shall be binding on the company and all its members, depositors, auditor, including auditing firm, expert, consultant, advisor, everyone who was associated. Company shall be liable to a fine of 5 lakhs if anything is contravened, 5 to 25, officer 25 to 1, imprisonment extend up to 3 months or both. Okay? Time pass penalty you can escape. Nothing contained in this section shall apply to a banking company. Nothing contained in this section can apply to a banking company. Understood? So guys, whatever is important, I'm telling you, first the application in case of class action suit, who will make an application, and what are the orders the tribunal can pass under section 245. Under section 245, that is called as class action suits. Okay, chalo, 2 minutes time, please read it, then we'll do the two different cases. Read, 2 minutes. Done? So guys, we are done with class action suits also. Now, these are two cases which were there in 1956 Act, and ICI had asked it already in the exam. So let's have a clarification on what exactly it is. So it says, foreign group of shareholders are holding 55% shareholding in a company, and an Indian group of shareholders is holding 45% of shareholding. So I would say this is a majority shareholding and this is minority shareholding. Okay? Now, but the AUA made it clear that both the groups will have equal managerial power. Both the groups will have equal managerial power. The AUA made it clear that both the groups will have equal managerial power. Now, due to some wrong action, okay, there was a dispute between both the groups. Okay, I have not covered the entire story, I am just telling you. Due to some dispute, both the groups had some, due to some point, both the groups had some disconnect basically. They were fighting. For example, appointment of chairperson. Foreign group says AB would be the chairperson of company. Indian group says Mukesh Ambani would be the chairperson of the company. Foreign group is saying, because they are holding 55%, Abhishek Bansal would be the chairperson. Indian group is saying Mukesh Ambani would be the chairperson of the company. AUA stated both the group will have equal managerial power. Now, Indian group were of the view that because foreign group is having majority shareholding, they are suppressing them. They are pressing their powers. उन पे दबाव डाल रहे हैं, उनको दबा रहे हैं, उनको प्रेस कर रहे हैं. Are they pressing them? See, if you check about the shareholding, foreign group have majority shareholding, correct, sir? But AUA made it very clear that when you're talking about decision making, both the group will have equal power. That means 50%, 50%. Foreign group is saying Abhishek Bansal will be the chairperson. They are saying Mukesh Ambani. So there is a dispute, there is a disconnect. Agreed. But neither it is operation nor it is mismanagement. No group is taking a decision. When no group is taking a decision, it results into a deadlock situation, guys. It results into a deadlock situation. When it results into a deadlock situation, then the tribunal will come and then it will wind up the company. Because if there's a disagreement on one point, there will be disagreement in all the points. So it's better to wind up the company. Okay? So it says both the Indian and foreign groups are equally strong in terms of managerial power and shareholding, and one is unable to suppress the other because both are equal. As such, there may be a deadlock, but not an operation. Hence, relief under section 241 होना चाहिए. करो उधर. 241 is not available. Relief under section 241 is not available. The powers of the tribunal are make it discretionary. In character, the tribunal may order the foreign group to buy out the minority shareholders at a fair price with the necessary permission. However, there was a deadlock in the management and both parties failed to buy the other group. So the company was wound up under just and equitable ground, आगे लिख दो, by the tribunal. Under just and equitable ground by the tribunal. By the tribunal. ठीक है? This is first case. Second, a company was controlled by two family groups. Group 1 had 4 directors, Group 2 had 2 directors. Okay. Due to family internal trouble, the Group 1 somehow convinced the shareholders to remove the directors of Group 2. Now, the Group 2 directors are planning to move to tribunal. कि सर ये लोग ने हमको निकाल के बाहर फेंका है. बोलो, क्या उनको रिलीफ मिलेगा? Will they get the relief? बोलो. No sir, no sir, no sir. They will not get the relief. They will not get the relief. They will not get the relief. Why? Because this chapter is covered only for members. गलत हुआ है, मैं मान रहा हूँ गलत हुआ है, wrong has happened, but that wrong has happened on director. Some other section में कवर हो जाएगा, पर यहाँ कवर नहीं होगा, ध्यान रखना. 244 का theory you will write. The election removal of directors is prerogative of members, and such an act cannot be treated as an operation unless there is a mala-fide intention. To constitute it as an operation, the conduct complaint of must affect a person in his capacity as a member of a company. Direct is outside the purview of 241. The relief would be given only if the effects are so severe that it would justify winding up the order. In the above case, group 2 cannot claim the relief from the tribunal. Some other section, some other act में जाइए वहां से मिल जाएगी, but 241 के चैप्टर की ऑपरेशन मिसमैनेजमेंट थ्योरी में कवर नहीं होते हो आप सब. दोनों के सर इंपॉर्टेंट, रिपीटेटिव, ध्यान रखना. एंड विद दिस चैप्टर इज ओवर. 241 application to tribunal for relief. 42 powers of tribunal. 43 consequences for termination of agreement. 44 right to apply. 45 class action suits. Chapter is over. ठीक है, चलो हाथ के हाथ ओपन योर क्वेश्चन बुक. विल बी सॉल्विंग क्वेश्चंस. Okay, let's solve the questions. So we are doing operation and mismanagement. 27 से 35. 27 से 35. Page number is 27 to 35, guys. Now, what does it say? It says, what is meant by operation? State whether the aggrieved party would succeed in obtaining the relief from the tribunal on the ground of the operation following cases. So guys, we have already studied operation is not defined in the act. It means any wrongful act or burdensome or a harshful or a wrong act. Okay? First, the majority of board override the minority of the directors, and the minority directors apply to tribunal complaining operation by majority directors. Guys, you have studied this. Majority directors is suppressing minority. Sir, नहीं चलेगा, नहीं चलेगा, नहीं चलेगा, नहीं चलेगा, नहीं चलेगा, नहीं चलेगा. Because the wrong act has to be done on the members. On the members. Number 2, a petition by majority shareholders complaining the operation by minority shareholders. Yes, चलेगा, चलेगा sir. कोई प्रॉब्लम नहीं है. Vice versa can also be done. Minority shareholders can also complain against majority. Majority can also complain against minority. ठीक है? You have to read the answers, guys. All the questions in this chapters are repetitive exam questions. Important. Read the answer. एंड ये केस को मार्क कर लेना. भगवान कूपर कह गए किधर? बड़ा वर्सेस बड़ा एंड वॉटसन लिमिटेड में. बड़ा वर्सेस बड़ा एंड वॉटसन लिमिटेड, एल जो वर्सेस एल एंड वॉटसन लिमिटेड. ठीक है, ये लिख देना हर जगह पर, ये लिख देना प्लीज. ठीक है. Done. Next. 2. Khatib Private Limited is a company in which there are 8 shareholders. Okay. Can a member holding less than 1/10 of share capital of company apply to the tribunal for relief for Oppression Mismanagement? Give your answers accordingly. So this is application, guys. Application. Section number 244, wherein you have studies 244 में पहला 100 members or 1/10 of total number of members, whichever is less. This is the first category. Second category was members holding 1/10 of issued share capital of company. Members holding 1/10 of issued share capital of company. बराबर. Now when I say 100 members, तो ये आ गया 8 members 1/10 का 8.8, तो मेरा मुंडी तो रह जाएगा ना भाई. तो you round it off to 1. So 100 members of 1, which is less 1. Even 1 member can apply, even though his shareholding is less than 1/10. Less than 1/10. क्योंकि वो सेकंड कैटेगरी अपने को करनी नहीं है, अपन उसमें कवर हो जाएंगे फिर. अंडरस्टूड. चलो रीड द आंसर. Read the answer from your book. Next, question number 3. Let's do it. The issued and the paid up capital of the company Children Limited is rupees 5 crores, consisting of 5 lakh equity shares of 100 each. Okay. The said company had 500 members. A petition was submitted before the T by 80 members holding 10,000 equity shares of the company for the purpose of relief against operation and mismanagement by the majority shareholders. Check as per Companies Act whether the said petition is maintainable. Also explain the impact of the maintainability of the power petition if subsequently 40 members who signed the petition withdrew. Okay. So again, guys, which section is getting attracted? Which section is getting attracted? Again, 244. So 100 members 1/10, which is less, or members holding 1/10 of issued share capital of the company. So let's see 100 members हो रहा है कि नहीं हो रहा. 100 members or 1/10 of total number of members, 1/10 of 500, whichever is less. So 100 members, 50 members, whichever is less. 50 people should make application. How many people? 50 people. But in the above question, 80 members have made the application. 50 was allowed, but 80 has done it. 80 has done it. The application is valid. The application is valid. The application is valid. Application is valid. Acha, what if 40 members withdrew their consent? बचा कितना अभी? 40. बचा कितना अभी? 40. Still the application is valid because the minimum requirement is to be checked only the time of making the application. Section 244. So first you will write the theory of 244. Then in the above case, chapify the questions, just copy the question, and then the conclusion, the working you have to show this thing. Okay? Read from the book. Next, question number 4. A group of members of Roche Limited has filed a petition before the T alleging various acts of the operation of mismanagement by the majority shareholders of the company. The petitioner holds 12% of the issued share capital of company. During the pendency of the petition, some of the petitioner group holding about 5% of the issued share capital of company wishes to disassociate themselves. मतलब 12 में से 5 बचा अभी 7 from the petition, and they along with the other majority shareholders have submitted the T that the petition may be dismissed on the grounds of non-maintainability. Check as per Companies Act. Second category, minimum 10% members holding 1/10 of issued share capital of company. That is basically 10% they can apply. So 12 have applied. The application is valid. Even after the withdrawal, the application is valid. Again 244 ka theory. Read the answer easy. Read. Next. Question number 5 asked twice in the exam. A group of shareholders consisting of 25 members decides to file a petition before the T for relief against Oppression Mismanagement by the board of Messrs. Fly-by-Night Operators Limited. Okay. The company has a total of 300 members and the group of 25 members hold 1/10 of the total paid up share capital, accounting to 1/15 of the issued share capital. Oh, what a line it is. The company has total 300 members and the group of 25 members hold 1/10 of the total paid up capital, which is accounting for 1/15 of the issued share capital. 1/10, 1/15. ध्यान रखना, ठीक है? The main grievance of the group is that due to mismanagement by board, the company is incurring losses, and the company has not declared any dividends even when the profits were available. The same example what I had told while explaining the chapter. As per the Companies Act, advise a group of shareholders regarding the success of getting the petition admitted and obtaining claim from the tribunal, obtaining relief from the tribunal. Bachcho, pagal jaisa people who are using the calci and calculating what is 1/10 and 1/15, it's shit. You don't have to do any damn thing. Why, sir? Why? Because both the reason what are given in the question, that is the losses and the dividend, is not an act of operation. अगर वो act of operation नहीं तो वो करने का जरूरत ही नहीं है ना. क्यों करने का अपने को फालतू में टाइम पास नहीं करना है. Nothing you have to do it. Just write, boss, it is not an act of operation. आपको आंसर पढ़ना होगा, easy answer. एग्जाम में 2 बार आ गया. अब बहुत सारे बच्चों के उंगली बहुत है. They have that problem in their life. They are like, सर अगर कुछ और एक्ट हुआ तो अगर ऐसा क्वेश्चन आया तो पहला चीज तो नहीं है सर. अगर आ गया पता चलना चाहिए कि बॉस 100 members or 1/10 of the total, whichever is less, तो 300, 100 plus 30, 100 or 30, whichever is 30 को करना चाहिए था. अब जो ये बोलो ना 1/10 of total paid up capital accounting for 1/15 कम होता है, तो the application is invalid. नहीं, कंडीशन ही मीट नहीं किया आपने कहीं भी, तो application is invalid. बट इस क्वेश्चन में बोल दोगे कि भैया एप्लीकेशन करने का जरूरत नहीं है, इट इज वैसे ही इनवैलिड बिकॉज ग्राउंड जो है वो गलत है. वो सही चीज है. It is not an act of operation. It is not an act of operation. Very important answer, guys. Read the answer. Asked twice in the exam. Next, question 6. Explain the merit of the following petition under 241 in the light of the judicial pronouncement. Pehla, a group of shareholders holding 12% of issued share capital of Unique Products Limited have filed a petition before the T alleging the various acts of illegal, invalid, irregular transaction entered into the name of company. So guys, always remember, the petition holding 1/10 of issued share capital of company, you can make an application, no problem. But just because it is illegal, invalid, irregular, it will not be said to be oppressive. The effects should be such that it should affect, the thing should go to wind up of the company. It should be so severe that it should result into the winding up of the company. And if it is resulting into the winding up of company, then only it is oppressive. Just mere section contravention, particular act of so and so section is contravention. It's also illegal transaction, right? It is invalid transaction. You cannot do it, but still you have done it. But it is not oppressive. The operation means it should be that severe that it should result in winding up of a company. If it is proved that it will result in winding up of company, then the application would be valid. So just a theory. Please read the answer. Now let's move on to the next question. 7. So it says ABC Limited used the business resources of the company in favor of the majority shareholders and completely excluded the minorities from the affairs of company. As a consequence, the minority members filed an application to T to look into the matters for the regulation of the conduct of affairs. State the action to be taken by the T in this situation. So guys, you will make a application under 241. ठीक है? So because majority पे दिया, minority पे नहीं किया, तो गलत किया ये तो you will make an application under 241. तो 242 के तहत वो उसके powers है ट्राइब्यूनल के, तो क्या क्या करेगा देखो. It says the problem is based on 242 with the powers of tribunal. In the given question, if on an application made under 241, the T is of the opinion that the affairs are being conducted or have been conducted in a manner which is prejudicial to the interests of members or members of public, then it shall be made, complaint should be made to T on an application by the party to proceeding. Then the T may make any interim order which it thinks fit for regulating the conduct of affairs of the company. So the line is only this much. The T may pass any interim order. T may pass an interim order. Okay? The T on an application, the minority shall make an interim order of the appointment of administrator or officer for managing the affairs of the company made on the application. Okay? And establish prima facie fact that the business resources, फिर ये पूरा question. The only point is they can make an interim order. They can make an interim order for the appointment of administrator or officer. ठीक है. 8th exam question. Mr. B. Ghosh is the MD of Food Plaza Restaurants Private Limited, FRPRL, the Food Plaza wala, was incorporated with the furtherance of JVA between B. Ghosh and Jack India Private Limited, both having 50% equal share in the said company. FRPL was to be governed by the terms and conditions set out in the MOA and AUA. JIPL held the board meeting without giving prior notice of such meeting to Mr. Ghosh, took decision to remove Mr. B. the Ghosh with an allegation of mismanagement of fund in FRPL. JIPL also pressurized him to sell his share at 5 crores instead against rupees 15 crore, which is the fair market price of Mr. B. Ghosh shares. So he was also a shareholder, he was also a member. Advised Mr. B. Ghosh has a right to claim any relief and would succeed in obtaining the relief from the T on the ground of the operation by JIPL. So see, important question. It says the act of JIPL to remove Mr. Ghosh and MD of the FRPL pressurizing him to sell his shares. So when I say sell his shares, मतलब क्या हो गया? वो shareholder हो गया. Below the fair market price, an act of operation and mismanagement. ठीक है? Operation basically, as per 241 and 242. So therefore the tribunal can pass order. Okay? Read the answer. Easy questions. Important. The other thing is it is covered. So guys, here Mr. Ghosh can be reappointed as the MD of the company by the T, and it can also issue orders for the future conduct of the company along with the provision of just and equitable relief to the applicant, that is Mr. Ghosh, because he was a shareholder. So here he had made an application in the capacity of a shareholder. Okay. Question 9. We have already done this. This is same as question 3. Right there, same as question 3. Same as question 3. Ten. The members of a company with no paid up share, that means guarantee company, filed a complaint against the change in the management of the company, due to which it was likely that the affairs of the company will be conducted in a manner which will be prejudicial to the interest of its 25 members. Okay. The total number of members were 100. On an inquiry and an investigation on the complaint, having a reasonable ground to believe that the transfer or disposal of assets of company may be against or to the interest of shareholders, the tribunal pass an order for such transfer disposal shall not be made during 1 year of such order. 1 year of such order. Okay. What is the eligibility of the members to file a complaint, and whether the management can dispose of certain assets in contravention of the order of the T. So now here guys, there are two sections which is attractive. One is 244 that talks about eligibility. So in case of a guarantee company, we say 1/5 of the total number of members. 1/5 of total number of members. 1/5 total number of members will come to 20, but here 25 members can make an application. Okay, the application will be valid. That's one part. Number two is basically on the selling of assets. So if the tribunal has passed an order that you cannot sell the asset, the tribunal can pass the order for maximum 3 years, okay? So I think this would be in section number 221, that would comprises of basically investigation chapter, and there would be penalty, and the tribunal will give the order for maximum 3 years, not exceeding 3 years. Achha, in case if you have sold the asset within those order of the tribunal can give the order for maximum 3 years. But in case if you have sold it within the whatever order the tribunal has given, you will be liable to a penalty. So here there is mixed sections 221, correct, 221 and 244. Okay? So you write here there investigation chapter. So this is a nice question, investigation chapter. Read the answer. The other 221 wala section you will not know right now because we have not the investigation chapter. We'll be doing it in the next few classes. So guys, remember it is a mix of two operation and investigation chapter together. Next, Messrs Sunshine Oils Limited, a listed company, as at 31st March 18, as per the audited financial statements, having 200 depositors with 50 crores of deposits in the company. Out of the 200 depositors, 20 depositors of the company have formed a group and have appointed Mr. Ram, a practicing advocate, who is not one of the depositors, as a representative to file an application, okay, into the NCLT to bring a class action suit, okay, against the company as there of the opinion that the management and the conduct of affairs are being conducted in a manner which is prejudicial to the interest of depositors or depositors. So when I say depositors, guys, section number 245, check as per Companies Act, will the application of Mr. Ram be admitted by the NCLT? So we have already done that. Okay, either the applicants will make an application, or they will appoint one among themselves, or they can appoint a lawyer, CA, CS who will file an application on behalf of them, but they have to meet the condition. Now when I say depositor, that means class action suit. So let us assume it is a, question mein diya, it is a listed company. So there were 100 depositors, or 5% of the total deposits of the company, whichever is less. So 100 depositors or 5% of the total depositors, whichever is less, or depositors owing 5% of the total deposits of the company in case of unlisted, and listed के लिए 2%, बराबर, listed के लिए 2%. So the application would be valid. application would be valid. And CA, CS, CMA, lawyer, anyone can make an application. Therefore the application is valid. You will write 245 ka theory. So this is 100 depositors or 5% of total depositors of company, whichever is less. So 100 depositors or total is 200, no? Okay. 10, whichever is less. 10. So 20 has made an application, the application is valid. And the second category is basically member enlisted में 2% check करते हैं, enlisted में 5% भी check, बराबर. So वो दिया ही हुआ नहीं यहाँ पर. So आप numbers पे जाओगे तो 20 में valid है, उन्होंने representative को अपॉइंट किया, that is also valid. Read 245. Same question what we have done. PBX Private Limited is a company in which there are 6 shareholders, S who is the director and also the legal representative of deceased shareholder, holding less than 1/10 of the share capital company, made a petition to tribunal for relief against operation and mismanagement. Check as per Companies Act whether it is valid. So again 244 ka theory you will write 100 members or 1/10 whichever is less. Legal leader of deceased is also entitled to file an application. या फिर members holding 100 members or 1/10, so 6 ka 1/10 would again be rounded off to 1. He can make an application. Therefore, as per the Provision of Act, a single member, even the legal representative of deceased shareholder, can present a petition to T, regardless whether he holds the shares of 1/10 or no. Therefore, the petition made by Mr. S is valid and maintainable. वो अपन ने 8 वाला एक क्वेश्चन करा ना, 8 वाला वैसा ही सिमिलर क्वेश्चन है 8 वाला, having 8 members. ये क्वेश्चन 2 लिख दो, सिमिलर टू क्वेश्चन 2. Same as question 2. Last question 13. चलो easy again. 245 is getting attracted. कर लो फटाफट, easy है. 244 is getting attracted. Do it on your own.
like to know about the last salary of.
So guys, this was again an exam question on section 244. अच्छा इसमें ना people get confused कि sir this is a question on directors, but he was removed from the directorship. But here it is cleared कि boss he was holding shares. ठीक है, he was holding shares also. So in the capacity of a shareholder, he has made a complaint. So but his application is not maintainable, and therefore the opinion of board of directors correct. As per proviso, Mr. Satri may make an application to the T in this behalf for the waiver of the above condition so that he may apply under 241. Because you must have studied in 244 that tribunal may waive all or any of the conditions, right? जो ऊपर दिया गया था. So वो रिक्वेस्ट करेगा, ये नहीं भी लिखोगे लास्ट वाला पॉइंट चल जाएगा, कोई प्रॉब्लम नहीं, आप बोल दोगे एप्लीकेशन इज नॉट वैलिड. ठीक है, easy 244 done. So majority question you saw it is only on 244, right to apply, that's it. So to mark the questions that you have to study at the time of revision. 13 के बाद you can take 11 also, 11 13 बाकी easy. 8 11 13 7 8 11 13 5 7 8 11 13 3 and 1 1 3 5 7 8 11 13. These questions 1 3 5 7 8 11 13 3 2 6 7 questions that you have to do it while you are revising very quickly. Done. So guys, we're done with operation and mismanagement. Also a 4 to 8 marks chapter, scoring chapter. It can come for MCQ also. Important section 244 and 245. Right to apply and class action suit, because class action suit my amendment was there, that 2% 5% wala category. Make sure you do it thoroughly. Okay, aim for rank 70+. All the best.